Hello, we are talking today about tort law and products liability. So, what is a tort? A tort is, as your book says, a civil wrong where one party has acted or they failed to act. And that action or inaction causes a loss to be suffered by another party. So we have the person who allegedly committed the tort, who we call the tortfeasor, and then we have the party who is bringing the action, who is claiming to have suffered some kind of loss. So we many times in tort law is we are compelling or we are trying to compel the tortfeasor or the wrongdoer to pay compensation to the injured party. Okay, so we've got these three categories of torts that we will be looking at. The first is intentional tort. The second is negligence, and then we have strict liability torts. Okay, so for the intentional torts, the key word here is willful. Okay, so we are looking at willful, which implies a deliberate choice to act or to fail to act in a certain way. Then we have negligence, and we are looking at accidental actions. And then we're looking at strict liability torts, where we're not really looking at the intent or the willfulness, but we are looking at what the action is. And if it falls within this category of strict liability torts, then the tortfeasor could be liable. So here we have an intentional business related tort called defamation. And we know defamation has been separated into these two torts. So we've got libel and slander. And the general rule is that libel is written and slander is spoken. So if it's defamation that has been alleged to have been contained in, let's say, a newspaper article, we're going to look at libel. And if it's something that has been spoken to someone or to a group, then we're looking at slander. And one way to remember that is slander starts with S and so does spoken. So to recover for defamation action, the plaintiff has to prove these four things, four elements. There has to be a defamatory statement. So that has to be a false statement that has the tendency to harm the reputation of the plaintiff. Okay, so it has to be a false, untrue statement that has this tendency to harm the reputation of the plaintiff who's bringing the action. Dissemination to a third party. So if someone says something in private or just says something to the plaintiff and a third party doesn't hear it in some way or see it or read about it, it's not defamation because we have to fulfill that second element. Specificity, it has to be about a specific person, a specific business or a product. And then that person, that business or the company who owns that product would be the party or parties bringing the action. So it has to be specific. It can't be just a general statement that's made about a particular type of product or type of individual, right? It needs to be specific. And then there has to be damages. There has to be some kind of harm. So if a statement is made, other people heard it, but there's really no harm, even if it was a specific statement, not defamation. All right. We also want to keep in mind that we want to know who's alleging the defamation. Okay. Is it alleged by a public figure or is it a private party? Because if the person alleging it is a public figure, such as a candidate for political office or a celebrity, could be Taylor Swift, the defamation has to be committed with malice or reckless disregard of the truth. So this public figure rule is based on this particular case. So it's a higher standard. It's much harder to prove defamation when the alleged victim is a public figure. They're less vulnerable to defamation. And, being in the public eye, being a public figure, they understand, or at least they're supposed to under law, understand and accept that there's this risk of public scrutiny. So it is harder for them to make out a claim of defamation because there is this requirement. There has to be malice or reckless disregard of the truth. Okay, so let's just talk briefly about this case that was in your that's in your book, and it is this case from 2018, Turner versus Wells. And the NFL hired a law firm, and one of its partners, Wells, was working on this, and it was an investigation because there had been allegations of bullying within the Miami Dolphins organization. So it centered around this one particular player, Jonathan Martin. He quickly left the Dolphins team midway through the season. He left the team and he checked himself into a hospital for psychological treatment, later explaining that he was taunted, he was bullied by the Dolphins players. So, as we said, Wells is this attorney who works for this very large, prestigious firm who is part of this investigation. And so, after lots of time investigating this case, he published a report. It's a 144-page report, and it concluded that the bullying by the Dolphins players contributed to this player's decision to leave the team. And it included several references in the report, based on the investigation, regarding this offensive line coach, James Turner. And it said that this coach's unprofessional conduct played a role in the struggles that this player had and the reason why the player left the team. And that this team and the coaches created this culture, this environment where bullying it took place, and players were discouraged from snitching on other players. There was this code that they have, and it concluded that the treatment of this player and others within the organization was offensive, was unacceptable in any environment. So the Dolphins, they received this report and they saw what was concluded in this investigation and they fired Turner. So they fired this coach. And this coach turns around and files a defamation lawsuit against that law firm that was involved in the investigation and the partner at the firm. And the trial court found in favor of Wells, the attorney, because the report consisted of opinions and therefore it wasn't actionable in a defamation lawsuit, right? We know that for a defamation lawsuit, one of those elements is there has to be false statements, right? These were opinions. And also that Turner, the coach, was a public figure and failed to adequately plead actual malice in his complaint. Much harder to prove defamation when there is a public figure. So Turner, the coach, appeals. Okay. So we know, looking at the court structure, which we've learned about, that this district court case would be appealed to a U.S. Court of Appeals case, and it was to the 11th Circuit. And the 11th Circuit affirmed the lower court's decision and said the trial court was correct in finding in favor of the attorney. And the court held what you and I all thought was the rationale here. The court agreed that the report was a product of a careful balance in the investigation and the statements were opinion based. So this was not false or misleading, it was opinion based. And also the fact that Turner, the coach, was a public figure and had this higher hurdle, higher burden in order to prove defamation. Okay, so now if someone brings a case against another or a company for defamation, what are the defenses that the defendant can claim? And one, of course, is truth, right? If the statement can be proved to be true, the person who claims that they've been defamed can't recover. So maybe it was a statement that harmed the reputation of the plaintiff in a big way, right? But if it was true, it wasn't defamation, right? Maybe it wasn't very nice for this defendant to say these things, but if they're true, it's not defamation, right? But of course, always be careful in what you say because even if the statements are true, right, it's expensive to go to court and to have to assert this defense. So in the business world, you want to be careful what you say, whether it's about someone you're working with, whether it's about a competitor, because you really don't want to have these expenses of having to go to court to prove the truth of a statement if you really didn't need to say it. Another defense to defamation is privilege. So we want to look at who is the person accused of defamation. did they have some kind of special privilege in making this statement? And if they did, they can't recover damages. So let's just quickly kind of go over these. What are these privileges? So absolute privilege, okay? If you're a government official, right, and you make a statement, let's say during a congressional debate, a hearing while in office, what you say is privileged. It can't be the basis of a defamation claim if you say it within the realm of your job as a government official. Okay. Similarly, judicial officers or during proceedings, right, in court, judges, lawyers, sometimes witnesses, what they say can also be privileged. State legislatures, and then there's also qualified privilege, right? So for those who are working for the media, let's say reporters, if they make unintentional mistakes of facts in their reporting, sometimes that falls under this qualified privilege, right? There's a lot that a reporter must gather, a lot of material, and they're relying on different things to gather that material. Sometimes unintentionally they make a mistake in their reporting, and that could be privilege. Of course, if they intentionally make a mistake, let's say they make up some facts regarding someone who's involved in a business in the area because they don't like the person, right? And these are false statements, right? Then that would not fall under this qualified privilege because it's not this unintentional mistake. Okay, there's a fair report privilege. If you rely on an official document by a public official, the privilege kicks in there as well. And also for employers. So many times, and this is a common occurrence, right? You apply for a job, you list your prior places of employment, and this new company who may be interested in hiring you may reach out to your prior employer. And let's say your prior employer says, this person was very, very nice. Many people like this person, but they were lazy. They just didn't want to get the job done and they relied on other people too much, right? You really would have a hard time bringing a defamation lawsuit against this employer because there is this qualified privilege. If what they are saying is true, it's their reference that they're providing to this prospective employer. Probably would be a hard time to claim defamation. Of course, they can't provide false, statements and things like that, but they are pretty much protected. So, fraudulent misrepresentation, okay, also known as fraud, um, provides a remedy to recover damages when the innocent party suffers a financial loss because of a false representation. And many times this comes into the context of contract law, right? So when there is a representation that's made when, let's say, parties are negotiating an agreement. Let's say I'm looking to acquire a business, and during our due diligence and gathering information regarding the other company gives me information regarding their previous year's sales. And I think, wow, this company is super profitable. I definitely want to buy this business, right? And then let's say I go ahead with the transaction and realize later that this representation that was made to me was fraudulently made. It was a false representation. So I can recover, right? The misrepresentation was a material fact, right? Super important to me in making the decision that I want to purchase this company. It was known to be false by the tortfeasor. Let's say we can prove that these records were falsified and what they were providing me was not true. Intended to persuade the innocent party to rely absolutely this company that wanted me to purchase it, they really wanted to persuade me. And that was the whole intent behind falsifying these prior business records. And I was damaged, right? I purchased this company. I thought it was worth $10 million, but it was actually only worth $500,000. So I was certainly damaged. So fraudulent misrepresentation. Okay, false imprisonment. Okay, so this is actually, it can be a crime as well, but we're talking about it here. So a merchant, okay, so let's say a Walmart, right? A Walmart, they have, security people there. And let's say a security person is sort of following someone around the store, maybe physically, maybe the cameras, because they think it looks like this person is taking things off the shelf and sticking those things in their pocket. And they continue to notice this, right? So, do they have this right to to take someone and to detain them in a certain area to see if they can recover the merchandise. So there is this privilege called the merchant's privilege. So let's look at what false imprisonment is. So merchants have this right. They can briefly detain a suspected shoplifter, but they have to be cautious because it could give rise to false imprisonment claim when they're doing so in an inappropriate way. They have to have sufficient justification based on the details to think that some kind of offense, that some kind of theft has been committed. So there's this merchant's privilege, and it shields a merchant from liability for temporarily detaining a party who is, and again, reasonably suspected of stealing merchandise. Okay, so again, reasonable suspicion of stealing merchandise. So to gain protection under this privilege, the merchant has to follow certain guidelines. You can see them here. Limited detention, right? Short period of time, case by case basis, limited to the premises, right? So only if they're confronted, let's say in the store or immediately surrounding the store, right? In the parking lot. Seizure of the property, they can take the property in plain view, but they can't search the accused shoplifter. They're not allowed to say, okay, show me everything you got in all pockets, everywhere on your person, in your bag, everything else. No, but if it's in plain view, they can. Coercion, they can't attempt to coerce payment, purport to officially arrest the party, right? They're unable to do that, or to obtain a confession. So if they have reasonable belief that this person stole something, they can detain the person for a short period of time. And call the police or whatever is deemed appropriate, but they do have this privilege. Okay, next category is negligence, and this is probably the tort that most of you are most familiar with. Okay, negligence. So as we see on the bottom, there are some pictures here, and there looks like there could have been negligence on behalf of a party leading to what we are seeing here. On the left side, it looks like this guy may have injured himself, maybe on the workplace. Maybe someone is responsible for that injury. To the right of him, right here, is the guy with the briefcase. It looks like he slipped on a banana peel. Okay, so was there someone who maybe was responsible for being sure that this area was clear of debris, and they breached their duty and this person fell and was injured? Here is a stethoscope, right? So we're thinking maybe this is a symbol of medical malpractice. Maybe a doctor was negligent in caring for a patient, maybe in conducting surgery, and the patient was injured or died. Here we see some sort of, it looks like demolition of a property. Could there have been negligence? Maybe someone was injured or someone's property was injured because this was negligently done. Okay, so injuries, damages suffered by another person, if they're caused because of a breach of a duty, there could be negligence here. So you may have heard of the famous McDonald's coffee case, the Liebeck versus McDonald's case, and this is a case from 1994, okay? And there was this plaintiff in this case, Liebeck, 79-year-old woman. And she went into the McDonald's drive-through, as many of you have probably done before. She purchased a cup of coffee, and she was in her car, and the car was parked, and she had the coffee between her legs as she put the cream and the sugar in the cup and mixed it up, and the coffee spilled. And she sustained pretty severe injuries, second and third degree burns, over 16% of her body, and she required skin grafting and other procedures to deal with these burns. So she sued McDonald's on this negligence theory, claiming that McDonald's breached its duty to her and it caused harm. And she actually she won the case, and the jury awarded her $160,000 in damages and $2.7 million in punitive damages, which is to punish the defendant. And that amount was actually reduced to $480,000. And in this case, it came out that this coffee was 30 to 40 degrees hotter than other coffees tended to be. There had been other people who were burned by this hot temperature coffee as well, and this was a notorious negligence case that you may have heard of. All right, so when we are faced with a set of facts that look like they could be negligence, we need to go through this five-factor negligence analysis to see if there is indeed negligence. So the first is duty. Did the tortfeasor owe a duty of care to the injured party? Okay, so for example, did McDonald's owe a duty of care to the injured party, right? Did they have a duty to serve coffee at a safe temperature? Breach of duty. Did the tortfeasor fail to exercise reasonable care? Did they breach this duty to serve coffee at a safe temperature by serving it at a temperature that was 30 to 40 degrees hotter than what is typical? And then we have 3 and 4, and we'll talk about those specifically, but they are different types of causation. And what that means is, did this breach of the duty cause the number 5, the actual damages or harm? Okay, so did the injured party suffer some harm? There needs to be that harm there, which is number 5. So 3 and 4 fall within this causation portion of these elements, and we'll talk about each one specifically. So did the breach cause the harm or damages? Okay, so what we are doing to figure out if a defendant had a duty of care is we are going to look at the defendant and compare them to what a reasonable person would have done. So the law imposes a general duty on every party to act as a reasonably prudent person would under the circumstances. Okay, so we are not judging the defendant compared to the most careful person in the world or the least careful person in the world, but what duty does a reasonable person have? So one thing that your book notes is the special relationship that a business has to its patrons to warn and assist any business visitors or patrons regarding potential dangers or harm. Okay, so for example, if there is a slippery floor they just mopped, this business, because of this special relationship, has a duty to warn its patrons, right? And many times they do so by putting up those yellow wet floor signs, and there is this special relationship, so they do have that special duty. Okay, so when we are talking about landowners and what duty the landowners have towards people on their property, what we need to look at is we need to look at who is this actual person on the property? How are they legally designated? Okay, so if someone is a trespasser on your property, the duty of care is lower than if they are an invitee, which is listed here. And having an invitee on your property, you owe them the highest duty of care. So what is that? Let's say you're a business and you have a customer in your store, or you're a hotel and you have guests staying at the hotel, or you are some sort of office and you have business clients who come into your office. Okay, so they enter the property with your permission and for the mutual benefit of you as the business owner and of them. And because of this, there's this high duty of care to ensure that the property is safe. So if this person is an invitee and they're injured on your property, your duty was pretty high. So you may have breached the duty. Let's look at what duties you owe. So to warn the invitee, so let's say it's your customer, of any known dangerous conditions on or about the premises. So again, let's say you have this wet floor, you've got to warn them. You have to have this sign. You also have this duty to inspect the premises for hidden dangers and take reasonable efforts to fix any defects. So you have to inspect on a regular basis and see if there are any hidden dangers or anything that could harm this individual who comes onto your premises as an invitee. Okay, so you have a store, you've got to walk around on a regular basis, make sure there's no merchandise on the floor, make sure it's clear of any kind of hidden dangers. You need to find those things. You have a duty to do that. Okay, very different if, let's say, you have someone who's trespassing on your property, right? You don't have a duty to warn them or to inspect or to repair. But there is this exception, even if there's a trespasser who's on your property, you, if you know, or you have reason to know that there is going to be someone who's trespassing on your property. Let's say there's a path and sometimes people pass through your property. Then there would be this exception to this no duty rule. Or if you have reason to believe that young children would trespass on the property, again, there is this higher duty. Okay. If a licensee, let's say a social guest, your friends come over, you do have a duty. You have to warn them of any known dangerous conditions, right? So let's say, if you did just mop, right, you want to let them know, but you don't have a duty to inspect for hidden dangers as you would if, let's say, you were a business owner and there were customers coming into your property. So when we're looking at the duty of care, someone is injured on someone else's property. To determine that duty that's owed, you need to figure out, were they a licensee, an invitee, or a trespasser? Okay, elements of negligence. Again, we talked about duty. This is breach of duty. So once we know that there's a duty, it has to be determined if a breach occurred. Okay, so here's a picture here of, let's say this is a daycare center, right? And the daycare center has a duty to keep these children safe, right? Certainly to lock the windows. So let's say this is a picture that was taken on a second floor classroom, and this daycare center did not lock this window, right? And they breached the duty, and it would be terrible if a child was harmed because of this breach of duty. So that would be the breach. Violations of safety statutes are sometimes referred to as negligence per se. So that means that if, let's say, someone is driving under the influence, right, there's statutes prohibiting that, and someone is injured, right, and this person who was engaged in the drunk driving is sued for negligence, that's negligence per se in and of itself. They violated a statute that was meant to protect others and to protect this person. So violation of a safety statute. Okay, just be aware of dram shop laws, right? So there are these laws that make these establishments like bars and restaurants that serve alcohol liable if a third party has been injured or harmed by someone who was intoxicated, who was served, continued to be served by a bar, by a restaurant when they were visibly intoxicated. If someone else is injured, the liability could be imposed on the establishment under a dram shop law. Okay, so we talked about negligence and there needing to be this causation. So cause in fact, right? The tortfeasor's conduct has to be the cause in fact of the damages suffered by the injured party. So there has to be this link between the breach of the duty and the damages. Okay, so for the example, let's say the McDonald's case example, right? So McDonald's breached its duty to serve coffee at a safe temperature by serving it at this incredibly hot temperature. This woman was harmed and it was caused by the breach of the duty. Okay, so it's this but for test that we use under the law. But for the breach of the duty by the tortfeasor, McDonald's in that case, would the injured party have suffered damages? Okay, so was it the cause? It's the link between the breach and the harm is the cause in fact. But we also want to make sure that it was the proximate cause, the legal cause, okay? Because just because something caused something else to happen doesn't mean that the person who breached a duty should be responsible. So the injured party has to prove that the tortfeasor's conduct was the closest in proximity cause of the damages, and that the conduct wasn't canceled due to a superseding cause. So we don't want these like far-reaching injuries that result to be the responsibility of someone who maybe was not directly connected. So most courts favor using foreseeability to define the scope, right? We don't want a result that's so unexpected by a defendant's conduct to necessarily lead to a finding of negligence on the defendant's behalf. So when we think of this proximate cause under the law, it's helpful to talk about this case called the Palsgraf case, which is a case from 1928, very old, but it's still taught and it's still helpful in understanding this. So this diagram here is just kind of showing what the facts may have looked like in the Palsgraf case. And I'll explain the case, and as we do, you can look at the graphic and hopefully it'll help. So Palsgraf bought a railroad ticket. So this is Paul's graph right here. She bought a railroad ticket to go to New York, and she was waiting on the platform for her train. A different train arrived on the platform, here we go, 100 yards away, allowing passengers to board, and it began to depart the station. So there were a couple people who were running to catch the departing train. And they grabbed onto the side. They tried to hoist themselves up onto the moving car. So one of the men, as you can see here, was trying badly to get onto the train, and he was holding a package. And the conductor on the train pulled him onto the train. But what ended up happening is the package was covered in newspaper that he was holding, and it fell. So it fell onto the platform, and it contained fireworks. And what happened? It caused an explosion on the platform. It shook the station so much that this large iron scale right here, it was used to weigh freight on trains right here. It was hanging right over Palsgraf, okay, who's the plaintiff in this case, and it fell on her, and she was severely injured. So Palsgraf, this woman, she sued the Long Island Railroad for the conductor's negligent conduct of pulling the commuter onto the train, which caused the explosion and ultimately her injury from the falling scales. So the opinion in this case was written by, and I'll actually take you to that page here, by Benjamin Cardozo, Judge Cardozo, who was later on the U.S. Supreme Court. And the court ruled in favor of the Long Island Railroad. And the reasoning was that because the conductor could not have known that the man he was helping onto the train had a box full of fireworks, the action of the conductor was not a proximate enough cause to incur liability for Palsgraf's injuries. Okay? Was not a proximate enough cause to incur liability for Palsgraf's injuries. Who would have ever expected that the conductor's conduct would have caused these injuries? So in addition to looking at a cause in fact, we want to make sure that there is actually a proximate or a legal cause as well. Okay, so the last element of negligence, actual damages. So to recover in a negligence case, the tortfeasor has to have caused another party damages, right? So there has to be some kind of physical harm from the injury caused by the tortfeasor. So it could be harm to a property. Let's say right here there was some kind of negligence on behalf of a contractor. Or it could be harm to someone like this person in the hospital, a broken bone or some kind of brain injury. Or it could be like the picture to the right, someone's car is injured or their property is injured in some way. There has to be actual damages. Okay, so there's different kinds of damages, right? There's out-of-pocket economic losses, right? Medical bills, different bills to repair property, to repair a car. Pain and suffering is another kind of damage that can be collected. Lost time from employment is another one. Also, when the conduct, tortfeasor's conduct, has been extremely willful, extremely wanton, what we call it, is with conscious disregard for the safety of others. So extreme carelessness, extreme recklessness. Courts can also award punitive damages, which is to punish the tortfeasor in addition to the other damages. Okay, defenses to negligence claims. Okay, we're going to talk about a few of these. Comparative negligence. So look at this picture on the bottom. Okay, this woman is riding on this golf cart and she falls off. She injures herself. She sues the golf course for her injuries. Okay, so she brings a negligence claim against the golf course. In cases such as this, where the injured party's conduct, right, has played a factor in the harm suffered. So I would say that this woman's conduct may have also played a part in the harm she suffered, right? It looks like she was somewhat negligent as well, right? She was riding on the back of the golf cart. That is not what she's supposed to be doing. She was being careless by doing that. Um, so the golf course can assert this defense of comparative negligence, saying, you know what? She was negligent too. So we need to compare the golf course's negligence to her negligence. And then the jury would divide up the proportion of negligence committed by the parties in terms of a percentage. So let's say the jury says, you know, it looks like she was 40% negligent and the golf course was 60%. So we are going to reduce the damages by 40% because we're comparing the negligence. Okay, contributory negligence is similar but different at the same time. So the minority of jurisdictions apply contributory negligence. So most apply comparative negligence, which we just talked about, but you'll see this the states here that do follow contributory negligence to some extent. So in contributory negligence, if this lady, even if she was just 1% negligent, there is a complete bar to her recovering anything. So if the plaintiff is at all negligent and their negligence at all contributed to their injury here, they are not going to be able to recover any damages from the defendant. Okay, assumption of risk, another defense to negligence claim. If the injured party knows that or should have known that the risk of harm is inherent in this activity and they continue to participate in the activity voluntarily, then the defendant can say, you know what, the plaintiff assumed the risk. So you guys have probably at some point signed some sort of waiver in which you were assuming the risk of whatever you were doing. So let's say skydiving, right? You sign a waiver saying, you know, I'm doing this at my own risk. I assume the risk, right? So that protects the skydiving company because they can assert this defense because they know you assume the risk. Same thing at these trampoline parks like Sky Zone. You're signing a waiver. You're assuming the risk. If you're swimming at certain places, you may see a sign that says you're swimming at your own risk. Okay, assumption of risk. Okay, last category, strict liability torts. Okay, so we said liability, certain cases, it doesn't matter if there was intent or negligence. We don't need to prove these things. The defendant could be strictly liable just by engaging in certain kinds of activities. So what are these activities? So we've got abnormally dangerous activities. So let's say this person is engaged in activities such as using harmful explosives, highly toxic chemicals. They're in the business of, you know, using chemicals in a lab in some way. They're using nuclear radioactive materials, right? So there's this severe risk of harm by engaging in these activities. So if there is an injury caused by this, there's strict liability. Products liability, right? So in certain products with design defects, there could be strict liability. If there was a hypothetical design that was safer, economical, practical, then the manufacturer of this product could be strictly liable. And there's also strict liability. You may see it with involving animals. If you are, let's say, if you are housing wild animals in your backyard, Or if you have a domestic animal like a dog and you are aware that they have this vicious propensity, right? That they've bit people before, but you keep this animal and you're not careful and they're around other people and someone else is injured, you could be strictly liable for those injuries. Okay, so products liability refers to the liability of any seller. So it doesn't have to be just the manufacturer. It can be the retailer who is selling the products, any intermediary seller, right? The wholesaler. And because of the defect in this product, there's harm to the consumer. So there's different ways to pursue a product's liability case. There's three theories. There's negligence. So you can claim that one of these parties was negligent in selling this particular item for whatever reason it might be, that there was some kind of warranty issue or strict liability, as we just talked about. So strict liability on the seller if the injured party can show the product was in a defective condition and that the defect rendered the product unreasonably dangerous. So the seller is engaged in selling the product and the product is expected to and does reach the user without a substantial change in the condition in which it's sold. Okay, so there could be strict liability here if someone is injured because the the defect. Okay, so unreasonably dangerous defects, there's different kinds of them. We'll just look at those. Design or manufacturing defect. So the product is designed improperly and foreseeable risks of harm are posed by the product, and they could have been reduced if there was some kind of alternative design. So maybe there was some kind of defect during the manufacturing process. That would have been a manufacturing defect. Or maybe it's just the design is faulty in some way and there could have been a safer design. Inadequate warning, failure to warn can render the product unreasonably dangerous, um, even without a manufacturing or design defect. Okay, so you've seen probably on ladders, there are lots of different kinds of warnings. Well, if there is this failure to warn, it makes the product unreasonably dangerous because of that. Improper packaging, a product can be rendered unreasonably dangerous by a defect in the packaging. Sometimes that is where the defect lies. Unavoidably safe. So some products are inherently unsafe, right? Some people are in the business of making guns, cigarettes, and other kinds of drugs. So that would also could be a product defect. Sellers who are sued for products liability, what kinds of defenses can they bring? Substantial change, right? So the user of the product who is injured, let's say they made some kind of change to the product and it wasn't used in the way that it was intended to be used. So let's say someone buys a ladder and they're injured, they fall off the ladder, but it's determined that they made the substantial change to the ladder. Let's say they built a seat on the top of the ladder, they put a cushion up there, they formed this whole seat back, right? They made this substantial change, right? So that's a defense that a seller could assert, this substantial change. Assumption of risk. Injured party has assumed the risk. They know or should have known of the risk and they disregard it by continuing to use the product or engage in activity. So let's say they own a particular car and there's a product recall that the manufacturer issued and they did not get the car fixed as they were supposed to under the product recall. They continued using the product, so they assumed the risk. So if they're injured, the seller could come back and say assumption of risk. Misuse of product. The injured party may not know of a certain risk, but they fail to use the product in a way that an ordinarily prudent person would. They can, the seller can use the defense of misuse of product. Okay, so let's say that they are stepping on the top of the ladder because they need to reach something really high, and that's not what the product is intended to do. You're not supposed to step on the top step. There's a warning there, so they're misusing the product, and that is a seller's defense.